Justice and Correctional Services. We have the Deputy Minister for Justice and Constitutional Development, Mr. John Jeffries. And we also have the Justice Albie, former Judge of the Constitutional Court. We also have the CEO of the Nelson Mandela Foundation, Mr. Sello Hatang. We also have the Executive Director of Access Chapter 2, who is also co-chair of the LGBTIQ entity, Steve Letsike. We also have the representatives of Val Heritage Activist Foundation, Ms. Atlehang Ramoji. We also have Professor Bonita Meyersfeld, who is joining us as well, part of the people that will be participating in the program. So we welcome all of you, and it's a great pleasure for us to have you in this program. And all South Africans viewing from different platforms, you are welcome to this important seminar, webinar. I think this critical and a milestone in the life of our nation, quarter of a century since our constitution was signed into law on this critical day, the International Human Rights Day. Thank you very much, Mr. Program Director.
Thank you, DG. Is the minister nearby?
Program Director, let me try and link up with the minister.
Thank you. DG, then you could then introduce the minister then for his keynote address, if possible. DG, I was asking if you could then kindly introduce the minister just before he joins us, if possible.
Yes, Program Director. Just wanted to first make sure that the minister is on the platform.
The program then. Hi. Okay, thanks. Bring me back now. Thank you. Colleagues, DG, I'm told that we are having some problems with the minister's connectivity issues. So can I then propose that we move then to the issues of the tribute messages and maybe then start with the chairperson of the Human Rights Commission, to give his contribution, and then we'll see when the minister will be available, if that is acceptable to everybody.
That's in order, Program Director.
Thank you. Can I then hand over then to the chairperson of the South African Human Rights Commission, Advocate Bongani Majola, to give a tribute message for this very important event today. Over to you, Advocate Professor Majola.
Thank you very much. Advocate Tupanyani, Program Director. May I also greet the Honorable Minister of Justice, Honorable Ronald Lamola, the Honorable Deputy Minister of Justice, Mr. John Jeffrey, the Director General of the Department of Justice, Mr. Dr. Mashabane, the regional representative of the High Commissioner for Human Rights in the Southern African region, Madam Abigail Noko, distinguished panel members present, distinguished guests, ladies and gentlemen, the South African Human Rights Commission feels privileged to be part of this very important occasion, and also to be given the opportunity to communicate a brief message as we commemorate the International Human Rights Day, as well as 25 years of our current constitution. The theme of this year's commemoration provides us a timely opportunity to pause and reflect on the last 25 years from the perspective of the pursuit of equality in this country. A lot of progress has been achieved in the 25 years to promote and protect human rights under the present constitution. So over the 25 years, numerous oppressive laws have been found to be invalid and unconstitutional. This has led to an even more progressive country than the one that we inherited from apartheid at the beginning of democracy. Additionally, new equality-focused laws and policies have been developed and passed, including the Promotion of Equality and Unfair Discrimination Act, which is called PEPUDA, and the development of the National Action Plan to combat racism, racial discrimination, xenophobia, and related intolerance. Additionally, the passing by Parliament of the 3 gender-based violence-related bills this year are much welcomed and pave the way for the further entrenchment of a culture of human rights in this country. There have been some challenges, though. The developments made in pursuit of equality cannot be overlooked. However, the challenges that currently exist in South Africa's society demonstrate the complexities of the journey that lies ahead of us. It is well documented that South Africa remains one of the most unequal countries in the world. Further, unfair discrimination has remained persistent, with equality-related complaints received by the South African Human Rights Commission, constituting the highest number of complaints received for a single right. Of these equality-related complaints, the majority are based on the ground of race, unfortunately. Race, therefore, remains to be a serious societal ill in this country. More recent developments in the form of the coronavirus pandemic have presented new challenges and brought to light inequalities in access to socio-economic rights and other basic rights. People have generally been living under severe strain under the lockdown, with increases in GBV, increased unemployment, closure of schools and delays to curricula, and overburdened health facilities, among many others. This inequality and division was starkly brought to the fore during the July unrest in the provinces of KZN and Gauteng, where over 300 people lost their lives, many lost their property, and still others their livelihoods. The onus for addressing these challenges does not fall on the government alone. Yes, in terms of Section 7.2, it falls on the government, but it does not fall on the government alone. It is vital that all spheres of society play their part in eradicating inequality in this country. Chapter 9 institutions and civil society have similar duties to promote equality and root out stereotypes and discriminatory attitudes, including the xenophobic attitudes that we see recently. The business and private sector across the country, their actors also have a role to play, particularly by ensuring that their activities and operations respect and promote the human rights of current and future generations. In closing, Program Director, there has been progress with respect to upholding certain parts of the Bill of Rights. There is, however, more to be done to transform the country into a more equal one, providing equal opportunities for the vulnerable and disadvantaged, and protecting our most vulnerable from abuse, including people with disabilities. Every member of the South African society bears a constitutional duty not to unfairly discriminate against others. We have rights and also we have got duties. It's time that we also emphasize our duties and we practice our responsibilities. Both state and non-state actors are subject to this prohibition. In order to move forward towards a substantively equal and socially cohesive future, every member of society will need to go further by actively promoting equality and addressing unfair discrimination, whatever its nature and wherever it occurs. So on behalf of the South African Human Rights Commission, I wish you all a constructive and fruitful International Human Rights Day. I thank you.
Thank you, Advocate Majola. Certainly the Human Rights Commission has been a very important part of this journey. And we hope that you will succeed to continue doing well in ensuring that we do get to the final destination of this journey. Our next speaker then will be Ms. Abigail Noko, representing the Office of the High Commissioner for Human Rights. Certainly herself and her office have been a long friend of both the Commission as well as the country in helping us, to really ensure that the vision in the Constitution does get translated into reality, and that we address some of the challenges which our chairperson of the Commission has also raised. Ms. Abigail Noko, over to you.
Thank you, Program Director. And I also wish to extend warm greetings to the Honorable Minister of Justice and Correctional Services, the Honorable Deputy Minister of Justice and Constitutional Development, to the Director General, to Judge Albie Sachs, the Chairperson and CEO of the Southern African Human Rights Commission, the CEO of the Nelson Mandela Foundation, members of the United Nations family and the diplomatic community, academia and civil society representatives, human rights defenders, and all of the esteemed guests that are with us today. Happy International Human Rights Day, and happy 25th anniversary of South Africa's constitutional democracy. This colliding commemoration is a milestone in South Africa's history. It is an occasion to recognize the significant contributions that South Africa has made to the international human rights system through its struggle for freedom against oppression. In turn, it underscores the contributions that the Universal Declaration of Human Rights has made to the Constitution, the bedrock of this rainbow nation. In today's commemoration, we stand on the shoulders of great giants. From Nelson Mandela to Ronald Letsike, to Eleanor Roosevelt, to Mehta Hansa, and so many leaders who were unrelenting in their conviction that we are all born free and equal in dignity and rights. They not only believed in rights, equality, and freedoms for all, but ensured that human rights would be enshrined as a matter of law. So as we meet on this 10 December, our commemoration brings us back to that fundamental human rights principle of equality, a principle that means that we embrace our diversity and demand that all be treated without any kind of discrimination. That no matter who we are, who we love, where we come from, and what we look like, we have equal opportunities to live in dignity and pursue our dreams. From the moment we are born, we have the same rights. All of us have the right to life, health, and education, to speak our minds without fear, to enjoy our days in a healthy environment. But the inequality, poverty, and unemployment inflamed by COVID-19 are pushing us backwards. The past 2 years have painfully demonstrated the intolerable cost of soaring inequalities. Around the world, and as a result, an estimated 97 million people will remain poor by the end of this year. People in vulnerable situations, such as women, youth, children, people with disabilities and migrants, and those without social protection have been the worst affected. Gender-based violence, lack of access to basic services and decent jobs are challenges and social ills that persist. The pact we have with we the people is at a crossroad. The Constitution and the international human rights treaties that South Africa has ratified offer us the way forward. We need a reinvigorated social contract that addresses deep patterns of inequality and breaks the cycle of poverty. Building back a more resilient and stable society requires a human rights-based economy that is more just, inclusive of marginalized voices, and people-orientated. Successive financial and health crises have had multidimensional impacts on millions of young people. We must ensure equal opportunities for youth to contribute to the development agenda. Vaccine inequality and injustice must also be urgently addressed. Global collaboration and solidarity will ensure fair distribution and the protection of the right to health and well-being for all. Finally, the human right to a clean, healthy, and sustainable environment for current and future generations must form the cornerstone of the new human rights-based economy. The Constitution was designed to build this nation, to unite in diversity, and ensure respect and human dignity for all. Let us do what is right. Let us work for equality. Let us stand up for human rights so that the next 25 years of this rainbow nation are better, fairer, and greener. I thank you, Program Director.
Thank you, Ms. Noko, for your kind words and a message of support, and reminding us that this journey does require lots of commitment and effort on all sides to make sure the vision is indeed realized. Unfortunately, the minister is stuck in a funeral, so we will then have to move to part 2. And then when he's available, then maybe hopefully towards the end, then we'll then have the keynote address. So in that regard, then I would then want to hand over to the Deputy Minister of Justice to talk about, to facilitate the panel discussion, and also, facilitate views from people like, he said we should call him Judge Albie, and then others in the panel. So over to you, Deputy Minister.
Thanks, Advocate Tipanyane, and good morning to everybody. Let me greet everybody, say all protocol observed. We do have a number of people on the platform. I'm told that we also may have some coverage from Newsroom Africa, who also may be covering some of this. This is then the panel discussion, and let me just by way of introduction say that today is International Human Rights Day. It's also the day 25 years ago at Sharpeville where President Mandela signed the Constitution into effect. The Constitution then took effect on the 4th of February the following year. That's about a month and a half later. So it's a sort of longish process. We had planned an event at Sharpeville, which because of the rise in COVID had to be postponed and to become a virtual event. There were other events also planned, such as Constitutional Hill Trust and the Mandela Foundation, who'd planned an event last night with President Ramaphosa at Constitution Hill. But anyway, welcome to everybody to this webinar. Just for those who don't know, the Constitution is the prime law of the land. Everything has to be consistent with it, and it requires special amendments to amend it, as opposed to ordinary legislation. It requires 2/3 of the members of the National Assembly and 2/3 of the provinces to amend it. Chapter 1 requires 75%, which is the general principles. Our Constitution is really our identity document, our birth certificate. It defines who we are as a country, and it has a profound impact on the lives of people. Former Judge President Pius Langa spoke of the transformative nature of the Constitution in October 2006, and he said, "This is a magnificent goal for a constitution, to heal the wounds of the past and to guide us to a better future. For me, this is the core idea of transformative constitutionalism that we must change." And surely that is the biggest achievement of the Constitution, that we have changed, and we've changed because of the Constitution. Since the Constitution came into effect, or really even before with the interim Constitution, which started in 1994, there's a substantial body of new laws that has emerged from all spheres of government to fulfill the constitutional mandate. There've been the creation of new democratic institutions, the repeal of discriminatory laws, laws dealing with land restitution, strengthening of land tenure, which are also being reviewed currently, the facilitation of access to housing and the provision of social assistance to those in need. Some of the laws were required in terms of the Bill of Rights and sought to address systemic and structural inequalities and prevent unfair discrimination and advance a transparent and open democratic society. There are 3 laws that the Bill of Rights requires, one on the promotion of access to information, another on the promotion of administrative justice, and lastly on the promotion of equality and prevention of unfair discrimination. And a 4th law not mentioned, but was originally part of the Access to Information Act, the Protection of Personal Information Act. So today's webinar is the Constitution. The topic of today's webinar is the Constitution as a catalyst for the achievement of equality. This aligns with the United Nations theme for International Human Rights Day today, equality, with the sub-theme, equality as the solution to provide opportunities within and access to a fairer and more inclusive society, with the generic call to action, stand up for human rights. So we're specifically looking at the issue of equality. Obviously, equality in South Africa, with its discriminatory past, can be, we know it has different meanings for different people. But the Constitutional Court has held, and starting with the Minister of Finance versus Van Heerden, that the Constitution recognizes the incontrovertible fact that we are all not equal in our country. If legislation and policies deny this reality, it will simply lead to an entrenchment of existing inequalities. And the court said that the jurisprudence of this court makes plain that the proper reach of the equality right must be determined by reference to our history and the underlying values of our Constitution. It goes beyond a mere formal equality and mere non-discrimination, which requires identical treatment, whatever the starting point or impact. So just to highlight that point on equality, we've had the courts have been reviewing legislation often finding sections of it unconstitutional if it doesn't comply with the Equality Clause. And there've been a number of new laws as a result, often of those judgments, or proactively combating employment discrimination with the Employment Equity Act, the Civil Unions Act to legalize same-sex marriage and prevent discrimination on the basis of sexual orientation. So there have been many achievements, and as a nation, we've made real and very significant progress. Access to services have been broadened immensely. And I think this is no doubt due to the justiciable socioeconomic rights in our Constitution and various groundbreaking judgments handed down by our courts. Millions who were previously excluded now have access to education, water, electricity, healthcare, housing, and social security. And it's important to highlight that many, if not most, of the advances we've made in our country are because of the constitutionally guaranteed human rights. Active citizenry has also been important in ensuring access to those rights. So that's the sort of good side, but on the bad side, I mean, this is a webinar about the Constitution as the catalyst for the achievement of equality. And the problem is that, as we all know, we are one of the most inequitable countries in the world as far as between the haves and the have-nots. Earlier this week, the findings and data from the 2022 World Inequality Report were released. And it shows while the richest South Africans have wealth levels broadly comparable with those of affluent Western Europeans, the bottom 50% in South Africa own no wealth at all. The top 10% own close to 86% of the total wealth, and the share of the bottom 50% is in fact negative, meaning the group has more debts than assets. Since 1990, the average household wealth for the bottom 50% has remained under zero. Recently, Mark Hayward, civil society activist, in the Daily Maverick article wrote, on December the 10th, South Africa will celebrate the 25th anniversary of its constitution. Thanks mainly to civil society activists, it's still alive, but it is chronically ill. The failure to realize the rights promised to the poor on the grounds that we don't have enough money is rapidly undermining confidence in the Constitution and the rule of law. So when it comes to equality and our Constitution's guarantee of equality, why are we seeing such high levels of inequality? And if Mark Hayward is correct in saying that the Constitution is chronically ill, how do we fix it? What more can we do in practical terms to ensure that the Constitution is indeed a catalyst for the achievement of equality? And are some South Africans taking human rights for granted, for example, choosing not to vote? Are we embarking on tick box exercises where we say we're implementing and giving effect to the provisions of the Constitution, but in reality, the impact is not being felt on the ground? So these are some of the issues which we hope our very esteemed panel will be able to address and unpack further this morning. I would therefore like to call on Justice Albie Sachs, former Constitutional Court judge, the first Constitutional Court, and author of a number of groundbreaking judgments, a activist before that. I think, Judge Albie, if you can excuse me not going into further details, but you have a long and impressive CV. But over to you, Judge Albie. Also just to the panelists, I've got a note here that everybody is meant to have 5 minutes. So if you can try and keep to that 5 minutes so that there is time for the question and answer session. Thank you very much. Over to you, Judge Albie.
Thank you, John. And, you know, this day, it brings me back to the time in exile. And every 10 years, the ANC would ask me, as a member of the Constitutional Committee, to write a paper on the Universal Declaration of Human Rights, how we see it as a South African. And I remember going through the Universal Declaration and showing that every single right mentioned in the UDHR was violated in apartheid South Africa. Every single one. It was quite astonishing. Apartheid was so pervasive that there wasn't an aspect of human life that wasn't vitiated by it, except for one. The only one that I couldn't point a finger at was the right to intellectual property. I tried very hard. So I had to say 99% of the rights in the Universal Declaration of Human Rights were violated by apartheid South Africa. So that was 68, 78 repeating, 88 I was blown up, lost my arm, sight in one eye, 98 I'm on the court. And now we have one of the most progressive constitutions in the world. And the theme of equality is very pronounced in the constitution. But how to apply it doctrinally, how to develop it. And the very first case where this cropped up full frontally was Prince Willem van der Linde, that dealt with fires moving from one farm in a fire protected zone to a non-fire protected zone. And there was an allegation of a lack of equality. And I was asked to write the judgment. And I felt this is not what equality law is about. Equality law is not about treating everybody alike in similar circumstances. Equality law is about people who suffered for being who they are. Black, female, Asian, gay, for being who they are treated in a discriminatory way. And our equality jurisprudence has to develop along those lines. So very early on, we decided we look at the impact of the laws. We look at systematic forms of exclusion and marginalization. We look not only at the intent of the laws and the practices, but the way they affect people in real life. And we try to secure fundamental respect for the dignity of everybody in a very diverse society. We were asked to go beyond simply dealing with human dignity as the core element, to use the equality provisions to get material equality, economic equality. And the feeling of the court was that was beyond the role of the Constitutional Court judges. That was the overwhelming project of Parliament. Social and economic rights mitigated the impact of material inequality, but basically our equality law was focusing on, if you like, the human soul, the indignities imposed upon people for being who they were. And as it turned out, there are two areas where our jurisprudence has become significant and is being cited throughout the world as path-breaking. The one is equality in terms of the right to be different, very much put to the fore in terms of, at that stage, the gay and lesbian community, in demanding the marginalization, the oppression, and the exclusion to which they were being subjected to because of their sexual orientation, that be removed. And the core to that approach was, you don't say to be treated equally, you've got to become like the mainstream. You have the right to be treated equally across difference. That's the unity in diversity theme. And the decisions of our court, our jurisprudence, and based on constitutional text, have been cited throughout the whole world, the right to be different in the context of equality. The second area where we've pioneered an approach is in relation to patriarchy. And that's been particularly important in the approach that the court developed in relation to customary law. When it came to the certification of the constitutional text, Contra Lesa and others argued very forcefully, very eloquently, that patriarchy was central to the nature of customary law. And so if we apply customary law, then the patriarchal principles must be embodied. And to the extent that the Constitution said the equality principle prevailed, the Bill of Rights prevailed, it was denying proper protection of customary law and upholding of customary law. We rejected that argument, and it meant then that customary law is a foundational source, original source of law equal to the common law in terms of its authority and importance, but like the common law is subject to the principles of the Constitution. And I think what we developed uniquely in South Africa was the notion of living customary law. That's a customary law that embodies the principles of equality between men and women. So we rejected the principle that boy children could inherit and girl children couldn't inherit. We said it was permissible for the Baloyi community to choose Mrs. Shilabane to be their traditional leader, although there was arguments against that in terms that was said in terms of customary law, only men could be traditional leaders. We rejected that, and we rejected that not because we thought we knew better, but we felt that that's what the community wanted. That was their choice. It's the choice of the royal family, of the community. Customary law, if it prevented women from becoming traditional leaders, was unconstitutional to that effect, to that extent. So these are progressive ways of developing true transformation in areas greatly significant to a huge number of people in our society. Women of half the population, poor rural women in particular, were very much at risk and very vulnerable if patriarchy continued to dominate their lives in terms of access to property, to land, to self-expression in a multiplicity of ways. So just to wrap up then, we haven't seen that the Constitution as such compels the judges to tell the executive and parliament what to do about bringing about more material equality. We say workers have to be protected in terms of their rights, to be protected in their dignity, fair labor practices, the right to strike. Women are protected, gender-based violence is expressly excluded, right to make decisions in terms of terminations of pregnancy, reproduction, expressly included. And all of this came from the fact, and I'll conclude with this, our Constitution was not the product of lawyers sitting in a smoke-filled or smoke-free room coming up with their ideas of what a beautiful Constitution would be. In that sense, it wasn't an elite product. It was produced in Parliament by the elected people from the nation with a mandate to bring about change. And overwhelmingly, I'd say more than half the people at the Constitutional Assembly, the 490 Parliament elected, had been in jail, in prison, in the resistance, in the underground. A very strong women's group was there with the support of the National Coalition of Women. There were strong trade union representatives. The workers had struggled hard for our democracy. They were well represented. So that's why we have a constitution with a wonderful text and a transformative text and a pro-people's text for the vulnerable, for the marginalized, for the excluded. And that's why to achieve the further advances in the material areas and other areas, the same struggles that led to the composition of the Constitutional Assembly and the debates and arguments that were ultimately triumphant in the CA, the same kinds of united actions of diverse people with the common goals set out in the Constitution will be required to make equality real in the lives of everybody in our country. Thank you.
Thanks very much, Judge Sachs, for that detail on some of the judgments from the Constitutional Court and also the constitution-making process. Our next speaker is then Mr. Sello Hatang, who is the Chief Executive Officer of the Nelson Mandela Foundation. Mr. Hatang, over to you.
Thank you very much, DM. Ntate Tipanyane, Minister, in your absence, DG, Justice Albie Sachs, Chair of the Human Rights Commission, Menoko, my friend Steve, Atlehang Ramoji, Prof. Meyersfeld. Good morning, ladies and gentlemen. Thank you so much for this opportunity to speak to you on this very important day. After Justice Sachs, what does one say? Because one gets stuck in understanding how we got where we are now. After the ideals that the Constitution or the Constitution-making process started off with, how did we get where we are, is the question. And I go back to the theme of the Constitution being the catalyst for change and for building a more equal society. And this serves as a reminder that we, as the people, are the Constitution. We are the Constitution. We should never forget that the Constitution remains what it is, which is a representation of ideals by people like Justice Sachs and others who thought it important to be a particular nation. But it rests on us as people to say we are the Constitution. If there is inequality, we have to take the blame. If there's no rule of law in our country, and we're beginning to turn into a gangster state where young people cannot just walk the streets and feel free to just be, or women cannot just feel free to walk on our streets, then we are to blame. The illness of the Constitution, as the Deputy Minister said earlier on, is a signal of the woundedness and a sick nation. If we point at the leaders, we must ask ourselves, where are we in that equation? Where are we as the people? Are we always waiting for a Messiah to come in and save us and show us that choices we make sometimes are choices we shouldn't be making for greater good that needs to come through? So choices we make also tell a story of our woundedness, our sickness as a nation. How do you explain that the Constitution gives us the power to elect leaders in the recent local government elections, and we choose a convicted rapist? We choose someone who, a fraudster, convicted fraudster in the Northern Cape. How do you explain that? That tells you that we are a wounded nation. We are a sick nation, and the Constitution is us. It shouldn't be that we then separated from who we are. We are scrambling because of the decisions that we've made in recent past. So if the Constitution were to become a lived reality for the great majority of our people living in this country, and a real catalyst for change, then amongst other things, we must ask ourselves why our education system is not empowering young people to thrive in the world. Why is foreign investment not flowing in order to grow the economy that we want? Why is the economy not vibrant, inclusive, and growing in liberatory ways? How come we are not reliable as a destination for people to just say, that's where I should go in terms of putting in their money? How do you explain that the N3 can be closed any other day? And yet we expect that the Constitution will deliver. The Constitution, I emphasize. And I say again, we are the Constitution. Democracy would be deepening, would be more equal, would be more united. Instead, we are more divided than maybe in most recent times that we can remember. How far are we from such a reality that Madiba dreamed of, that Judge Albie Sachs dreamed of? So constitutionalism should be the overarching framing or theme for the work that we need to be doing. Are we constitutional beings? We should ask ourselves. And by constitutional beings and by constitutionalism, we should mean the use of the Constitution or constitutional instruments to transform fundamentally a society shaped by centuries of oppression. Sadly, Most often than not, the Constitution is used to protect power, privilege, and property. It must be reimagined as the means for distributing power, privilege, and property. But how does this vision translate in practice? In the context of South Africa today, where, if we are brutally honest, democracy is not delivering, where inequality has reached obscene levels, as everybody has said before me, where survival has become a reasonable measure of success. What could be done differently at a time like this? What should look like, what does a practice look like, as opposed to theorizing? So as I close, I urge all of us, those who are on the panel and those who are watching this, the webinar this morning, we must commit ourselves to say, we want to do differently. We want to ensure that those who gave us the power to bring about change in the lives of many, that we do bring about that power. And that everything that we do is part of an ecosystem that ensures that we become a healed nation, a nation that does not then blame the Constitution as a sick instrument, but rather say, maybe we are the sick ones, and how do we ensure that we do differently? It's in our hands to build that country, to give hope where there's hopelessness, and to keep reminding ourselves, we are the Constitution. It will never move an inch until we move to make it different. Thank you very much.
Thanks very much, Sello. I think that's a very important point that you've made, that we are the Constitution. It's the people of South Africa who are the Constitution, and we all need to play our role in ensuring that the ideals of the Constitution are lived up and we have the type of society we want, rather than trying to find always other people to blame. The next speaker is Ms. Steve Letsike, who is down on the program as being from Access Chapter 2, which is an organization working in the LGBTQI sector and also with women's rights. But also Steve is also the co-chair of government, or the Department of Justice's National Task Team on LGBTI people. And she is also the co-chair or the deputy chair. I'm not sure which, Steve, I was confused at our last meeting in Durban, but the co-chair or the deputy chair of the South African National AIDS Council. But over to you, Steve.
Thank you so much, Deputy Minister, Honorable Jeffrey. Let me also appreciate, the overall program director, CEO of the South African Human Rights Commission, Advocate Tipani, in his absentia, Minister of Justice and Correctional Services, Honorable Lamola, Director General of the Department of Justice, Advocate Mashabane, Chairperson of the South African Human Rights Commission, Advocate Majola, the Regional Representative of the Office of the High Commission for Human Rights, Ms. Noko, to my fellow panelists, of course, former Constitutional Justice, Albie, my friend and comrade, CEO of Nelson Mandela Foundation, Mr. Hatang, representative from the academic field, Prof. Meyersfeld, and of course the youth representative from the Val Heritage Activist Foundation, Ms. Ramoji. Fellow delegates, participants, friends, siblings joining us from various platforms, a very good morning to you all. DM, it is a great honor and privilege to be joining this session. It is a most important event that brings all of us together, and we join the rest of the world in marking, first we mark the 73 years of the anniversary of the Universal Declaration of Human Rights, but most importantly, it's also marking our own important 25th year of South Africa's constitution signing into law. I consider this day, 10th of December, an historic moment in our lifetime in the quest for human rights, for freedoms, for dignity and integrity. Today we speak and we reflect on the history of both the tragedies and triumphs we have had as South Africa, but also the rest of the world. And both the Universal Declaration of Human Rights and the Constitution were adopted at times when nations were deep rooted in scars of war, and when South Africa were also in the pathway of repairing the injustice of the past. Our history of South Africa shaped us and continued to shape us, but we do have a long history of colonialism, of prejudice, criminalization, stigma, and discrimination that continued to divide us. We both, while both these documents gave hope and became a beacon of hope to set up a vision of unity, of respect for all, of valuing the rule of law that guides arms of states and its citizens to protect, promote, and fulfill the human rights for all. It is fundamental, DM, to the cause of human rights that we protect equality and we promote equality for all people from discrimination and violence. And it should be obvious that there are many different ways to be human beings. We need to respect and embrace these differences, not criminalize them, not attack people, not deprive people of their equal rights or protection of law just because of how they are seen as different. The struggle for rights of LGBTI people is a core part of the human rights struggle, as the panelists have indicated. And yet in many parts, here in South Africa and also in the world, members of the LGBTI people continue to be targets of brutal attacks, brutal murders, and discrimination and victimization, and of which, to some extent, many are left unpunished. It is also essential that we defend and protect the LGBTI people from any kind of violence and discrimination. There shouldn't be anything or nothing controversial about stopping people being murdered or executed by agents of hate. And I call them agents of hate because it is regarded hate crimes, simply because of who people love. Tackling extreme violence does not require any new norm, so it's not new thing. It should not become any controversial. Let us reflect a little bit in the streets of our communities in South Africa, but also in Africa. For far too many painful years, there has been a muteness, a vast muteness and silence and quietness about African daughters and sons, African men and women, African gender non-conforming person in all their diversity, who self-determine, observe their bodily integrity, who yearn to love and who also embrace their partners. And this muteness have denied recognition, denied reality, the truth, and throughout the history of LGBTI people have been predominant here as in anywhere else in the world. And this muteness and silence has created injustice, for it was born from control, fear, and from disrespect of humanity. And again, both Universal Declaration of Human Rights and South African Constitution proclaim that everyone without distinction has the right to life, liberty, and security of persons. Where there's been patterns of hate-motivated acts and violence, one, for an example, based on gender, sexual orientation, and gender identity. And also where the state does not act to prevent or effectively address those attacks, it is failing to live up to the obligation. And I think it is some of the examples that we have to reflect on and as we seek to speak about equality. While we seek a catalyst approach ourselves, we have to reflect on what has happened just this year, 2021, where LGBTI people have experienced a horrific brutality with over 21 LGBTI people here in South Africa murdered, brutally murdered, over 30 cases of reported physical and sexual assault. And it is important to also note, while we talk about numbers and stats, Love Not Hate campaign partners reported in 2016 that 88% of LGBTI people do not report any incident that happened against them. And it is telling us 1 out of 25, only 1 gets to report. So the numbers that I've reflected on, you would then realize why we are where we are. But the worst still, when the victims of attack seek protection, they are frequently subjected to intimidation, secondary victimization, abuse, including this from police or officials. We also know that violence is not only the issue that is troubling the LGBTI people. The other issues that troubles LGBTI people include disowned by families, denied and expelled from school or work, rejected by churches, denied affirmative social services that includes health, safety, justice, or even education. And it is imperative to realize that it has to do with discrimination and victimization. And to some extent, it also includes the loss of work or job opportunities for that matter. While we acknowledge that there is a complex anxiety at play in the way—
Steve, sorry, can you start winding up?
Yep,
Can you start winding up? You've gone over.
I'm counting my time. Thank you, DM. We have to acknowledge as well some of the challenge that we are reflecting to. The challenge also of in Africa and globally as well. 71 countries across the world, of which 31 are in Africa, still criminalize homosexual act. The result is impunity. Too many victims goes without recognition, remedy, or justice, and too many perpetrators are free to strike again undeterred by the prospect of the rule of law. And I think South Africa has demonstrated leadership with the constitution and the constitutional development. The entity that was established became the beacon of hope, where we are now in the 3rd generation of the national intervention strategy, where we track cases, where we track progress of justice. And I'm hoping that government will also still put enough investment to ensure that prevention measures are in place. South Africa's progressive laws have demonstrated through upholding the human rights, but these strong national trends, which are regarded global trends, must ensure access and equality for all. Now, while I end, Deputy Minister, I want to recognize that many organizations and many LGBTI people have been doing so much to open the people's heart and mind, which is change behavior efforts through continued campaigns, but we also need further education of these rights to people for respecting diversity, including diversity of LGBTI person. Now, 2 laws that must be quietly thought through: hate crimes law must be in place, hate crimes and hate speech law must be in place, and South Africa must fast track that process. But I also call on the South African Parliament and government to ban conversion therapy and practices. Research that has now been concluded, 58% of LGBTI people have experienced conversion practices in South Africa, and of which 47% have experienced conversion practice under the age of 18. And it is something that we need to think through, ban conversion practices. So we need leadership, we need continued religious leaders, traditional leaders, to play a positive role in this change. I believe that profound positive change is possible. I've seen it in my own lifetime. It can be done by all. We need allyship in this effort. Thank you so much, Deputy Minister.
Thanks, Steve. We are unfortunately now running a little bit behind schedule, so let me move straight on. The next speaker is Atlahang Ramoji. Atlahang is a youth representative from Sedibeng and was nominated by the Vaal Heritage Activists Foundation. So Atlahang, over to you. Please, if you can, stick to the 5 minutes. Thank you.
Thank you, sir. Greetings to the President of the Republic of South Africa, President Cyril Ramaphosa, Ntate Ronald Lamola, and other ministers and deputy ministers here and present. Representatives of the United Nations agency present here, all the executive mayors and all the councillors also present. Speaker of Sedibeng Municipality, Councillor Memwiponi Mudikeng, and speakers from local municipalities of Mfuleni, Midvaal, and Lesedi, councillors, leaders in business chambers, corporates, and entrepreneurs, labor organizations here and represented, as well as leaders in state enterprises and in government administrations. Bommele Bontate ba Khulumani Support Group, representing families of victims and survivors of brutally of what happened, of what apartheid had left as a legacy in our beautiful country in 1994. My deepest gratitude goes to leadership of Vaal Heritage Activists Foundation for this huge opportunity to address the occasion to mark the 25th anniversary of the signing of the Constitution of the Republic of South Africa in Sharpeville by former President Nelson Mandela. President Ramaphosa and his administration, thank you for choosing to come back here in this area of the Vaal. Literature I read and conversations I have with my parents, my teachers, my uncles and grandparents told me that the primary reason Sharpeville was chosen for that historic occasion in 1996 was because 1960 Sharpeville massacre epitomized gross human rights violation, injustice, brutality, and criminality of apartheid state. In the words of former President Nelson Mandela at the ceremony of the signing of this constitution here in Vaal on the 10th of December 1996, he quotes, out of many Sharpevilles which haunt our history was born an unshakable determination that respect human life, liberty, and well-being, which must be enriched as rights beyond the power of many forces to diminish, in closing quote. 25 years of exercising rights guaranteed and enriched our constitution. We are on a cusp of losing hope in a democratic project and the dreams it represents, as well as the society and you and your generation have committed to build since 1994. Over the last 25 years, a democratic government worked hard to restore dignity of many people, providing free education, increased access to higher educational skills and development opportunities. People benefited from free housing, electricity, water, libraries in townships, and etc. This constitution shall remain shallow and meaningless if we are not going to pause and reflect on its meaning, impact, and its intent. We must work together as government, industries, and ordinary people in non-governmental organizations to put dreams of Ntatemoholo Mandela, yourself, President, back on track when this constitution was finally adopted many years ago. It is a great legacy in your generation can bequeath to us as the present generation and future generations to internalize, embrace, and live its provisions as we continue in a journey to create a country in which we all and equally belong in it, Black and white. It must represent a heritage in which generations after generations will celebrate not only its existence, but its ability to qualitatively and quantitatively used to effect change, transformation, build a united, non-racial, non-sexist, democratic, and prosperous country. This important day on the 10th of December, it coincides with an equally important moment in global politics, since it also marks United Nations General Assembly having adopted the Universal Declaration of Human Rights in 1948. The theme adopted by our government for this year, the Constitution as catalyst for achievement of equality, and the UN theme, equality is the solution to provide opportunities within and access to a further and fairer and more inclusive society. These themes galvanize everyone in our country and to the world to stand up for human rights as we review and reflect on our country's lived experience of constitutionalism, working to strengthen the constitutional values of human dignity, the achievement of equality and advancement in human rights, freedom, non-racialism, and non-sexism. From my eyes, what do I see since our constitution was signed into law? The reality on the ground 25 years later is that racism, intolerance, prejudice continue to live and breathe among our people. A gap between rich and poor is growing every day. Gender disparity, including pay gap in the workplaces between men and women, still alive in many private and public institutions, corporates. I see prevalence of xenophobic tendencies, breeding of fear, violence, and destruction of property under the guise of service delivery, which continue to flare up every day in communities. Scourge of violence against women and children, femicide and gender-based violence has reached a scale of pandemic of a special type in South Africa and must be defeated. Queer communities are targeted and exposed to gender-based on to dangers based on gender identity and sexual orientation. It is for this reason that the 25th anniversary of the signing of the Constitution of the Republic of South Africa becomes an important moment to take stock, reflect, assess, and review various intervention in judicial and constitutional means to migrate as well as to live expectations promised by the Constitution itself. It means an ongoing process, an ongoing work of building a truly united and diversity nation will not happen on its own, but demands more practical and sustained programs on the ground. People must be able to access services, institutions, resources, advice, and the means to enforce their rights and strive for equality as promised by the Constitution. Happy 25th anniversary of our beloved Constitution. We shall never abandon this legacy project bequeathed to us by a generation of brave men and women who fought for freedom, because in every country where the Constitution and rule of law fail, women and children, most vulnerable, are the primary victims. Not in our name, not in our lifetime. Constitutionalism forever. I thank you.
Thanks very much, Atlahang. Without further ado, if we can then call on our last panelist, Professor Bonita Meyersfield, who is a advocate at the bar, and then also a professor at WITS. Bonita, Professor Meyersfield, over to you.
Thank you, Deputy Minister. And
please stick to time. It's difficult to interrupt. Yeah.
No, I'll only be about an hour and a half, Deputy Minister. It shouldn't be too long. Greetings and acknowledgement, or protocols observed, and to my fellow panelists, the speakers of this event, and also the organizers of this event. When Adolf Eichmann, the infamous Nazi and war criminal, was tried for war crimes committed during the Holocaust, the famous and renowned philosopher and journalist and author Hannah Arendt wrote about the banality of evil. The principle was that true evil and true perpetrators of evil are often not monsters, are often not larger than life, but occur in the minutiae of everybody's day and go unnoticed and unaddressed. And in many ways, while the celebration of the Constitution must not be abandoned, there is, I think, an uncontested acknowledgement that its implementation for the majority of the people in this country has yet to take effect. And there are there are many ways in which one can discuss this, but there are three ways in which I think this manifests, and they are examples to which I'd like to speak briefly, but perhaps we could speak more during the question and answer session. The first way in which the banality of evil manifests in South Africa, in my view, is around the lower courts in this country, in the magistrates' courts in particular, because this is where the majority of people in this country seek justice. While the superior courts are, of course, an indelible part of the implementation and the development of our constitution, there is a disproportionate, in my view, focus by the state and by the components of the judiciary on the superior courts. It's at the magistrates' courts where people come for their protection orders to lodge complaints about rape and in respect specifically of gender-based violence. Because the banality exists in coming to court and being told that the matter is delayed once again. It's coming to court and being told that the systems are not working and are down, that the recording is not available and is down. And for 6 years, a victim survivor of gender-based violence, some of the worst violence that we know in this country today, will have to relive their trauma every few months, come back to court and be returned home without any justice. And it may take as long as that for the first time they get to talk about their experience. And so it's no wonder that there's a massive attrition of cases. This is the banality of evil. The second way in which it manifests is at the level of the civil service. The departments of Home Affairs, the departments of Social Welfare, these are the departments that service the majority of people. And I'll give you an example of how the banality of evil manifests. In order to get a SASSA card, to access one's social grants, one needs an identity document. In order to get an identity document, one needs to fill out a form, which assumes literacy, and one needs about 100 Rand to process it. For the people who are most in need of that income, who are most in need of that grant, are in fact foreclosed from applying for it. And then even when applying for it, and even if successful, and even if they find the money to obtain that SASSA card, all sorts of impediments continue to exist around transport, around accessing those grants, and not least of all because the way in which the former company in charge of the distribution of social grants was able to make an untold fortune, the largest fortune out of the manipulation and exploitation of the data of the poorest people in this country. And the final way in which I think this manifests the banality of evil is in the increasing lack of transparency that we see in this country. And it's a commitment increasingly to this notion that some things are in fact legitimately non-transparent. And in particular, I'd like to talk about the arms trade, because one of the key characteristics of apartheid was the extent to which the apartheid government and many of the countries, particularly in the global north, who decried apartheid publicly, still participated in the arms trade, in the extent to which the arms trade was responsible for conflict and still is in our region. The arms trade itself, of course, responsible for the violence perpetrated against Judge Albie. And we see today an increasing lack of transparency around the arms trade. And we must be very cautious about this, not because the arms trade is the only industry that requires transparency, but because it is the one that was so akin and so characterizing of the apartheid government. The banality of evil, and I'll end on this point, the banality of evil is perpetrated precisely because it falls below the radar of public discourse. And I would urge the state, and I would urge the judiciary, and I'd urge those who have a platform of public commentary to think about the very banal ways in which people continue to suffer, particularly economically. We pay the least amount of money to the people who look after our children and clean our homes. We pay nothing to the people who are responsible for recycling in this country, committing themselves to helping end the greatest crisis of climate crisis in the world. They earn nothing. We pay our educators the least, our police services the least, and yet our greatest harms in access to security, in access to health, and in access to education. So the banality of evil is, in my view, where we need to address the challenges facing the Constitution. I'll end on that note.
Thanks very much, Professor Maisfield. We are now running more over time, but it's now the question and answer session. Because of time constraints, what I want to do is go through, you should have seen them, but just highlight some of the questions on the chat or comments on the chat. I think we've only got time for one set of responses, and I'd like to go in reverse order. So that would be starting with Professor Maisfield and ending with Judge Sachs. So just on the chat, I mean, it's a diverse set of comments. I'm not going to allocate questions, but you're going to largely be limited to I think 3 minutes each. There's an issue of problems of gender-based violence, survivors not having basic rights like access to justice, legal aid is a systemic failure, no one takes accountability. Another one also on gender issues, that the Constitution is a crush grinder of women in South Africa. And a point made that to some extent, backing up Mr. Hatang's point about we have a generous appetite for constitutional delinquency in all parts of our country. Then there's a point about the judiciary violating constitutional rights. People with power and influence easily manipulate the judiciary, violating our constitutional rights. I'd like it if particularly Professor, anyone can respond to it, Maisfield and Judge Sachs, respond on that, because there seems to be a bit of a growing narrative about or attacks on the judiciary. There's issues of access to information. There's no way we can address inequality if we don't know what our rights are or the powers that the Constitution contains. The Constitution is a public document, but how do you make it more accessible? It's also the issue that Professor Maisfield raised. You don't raise that we do have PAIA, and we now have the information regulator being able to make binding orders as far as PAIA disputes and whether that is going to make a difference. Then there's issues relating, well, no, let me leave that one. There's issues then, there've been a few issues relating to people of Khoi or San descent and complaining that they are an oppressed, marginalized minority in South Africa who continue to remain excluded. There's an issue of statelessness and the problem of the issue of the children of illegal immigrant stateless persons. There's a point made about no sign language interpreter for the event. Do you have one? If so, they're not visible. Well, it would seem we don't have one. They would have to be visible. So those are the questions largely from the chat. Some other ones maybe that people may want to look at responding to is how do we strengthen the rule of law? What do we do about the realization or the lack of realization of socioeconomic rights? what with youth and unemployment, what solutions can the Constitution bring to the lives of young people? And the issue of corruption, and how can the Constitution be used to overcome the ill of corruption and contribute towards a more just and equitable society. So I would then want everybody to pick whichever questions they would want to respond to, but please, if I can limit you to 3 minutes so we can remain within the program. We're meant to finish at 12. We can go over, but maybe there are some people here who can't be with us. So Professor Myersfield, if we can start with you, please. Thank you.
Thank you, Deputy Minister. It's the greatest challenge is trying to focus in on only one of those seminal challenges. So in focusing, I do not in any way disregard the seriousness of the others. But let me perhaps focus on the issue of accountability, because I think that speaks to many of these points that have been raised. And I'll speak specifically in respect of gender-based violence and violence against the LGBTQI+ community. I often say that if you have a child and you tell the child, you know, don't put your feet on the couch, or wipe your feet when you come into the home, and the child doesn't listen to you, and all you say is, don't put your feet on the couch, without any consequences, the child will continue to put their feet on the couch. And while I'm not comparing the perpetrators of contravention of the law to children, that would be a generous comparison. What I am comparing is the point that a lack of accountability and a lack of consequences are themselves complicity. So when we talk about gender-based violence, the prosecution, there's less than an 8% successful prosecution of crimes of gender-based violence, and specifically rape in this country. Bearing in mind that there are disproportionate, we don't know what the statistics are, but some say that only 6% of rapes are even reported. Of that, only 8% actually reach finality. And we don't even know what percentage of that results in a finding of guilty. What we respond to is when a victim survivor is disemboweled. What we respond to is when a woman is found hanging on a tree. And we cry out as a nation globally, collectively, we must end gender-based violence. We must end this kind of deplorable action. But when individuals speak about their harm and their experience, we're told that they are liars. We're told that they can't speak publicly and on public platforms because the perpetrators' lives will be ruined. And the way in which, as I spoke about earlier, the minutiae of the mechanics of the country stand against and impede access to justice is really what we should be talking about. And where the biases and prejudices of individuals are imported into the execution of their jobs, such as police officials telling women that if they're in a relationship, it can't be raped, where we have administrators of the corporate South Africa telling people that sexual harassment is something that must just be accepted, or that there has to be a proper process, knowing that the process is always stacked against the victim survivor. We need to be more creative and imaginative and empathetic in our understanding of how people experience violations. We need to be able to be kind to one another, but above all, there needs to be accountability, and that speaks to corruption, that speaks to the failure to recognize the Khoisan community's rights and cultural heritage, the First Peoples, our failure to properly respond to the displacement in society of people who don't fall between black and white, the colored community in particular. The fact that we have children in this country who are undocumented, not because their families are, and it's a dreadful term, illegal immigrants. People are not illegal. They may be in this country without documents. They may be in this country in contravention of immigration laws, but they are not themselves illegal. But our lack of empathy towards those children is something that I think results in the violations we are all decrying and are inconsistent with the values of the Constitution that Judge Albie spoke to so eloquently, and Advocate Majola and other members of the panel. Thank you.
Thanks, Advocate Maisfield. Then if I can ask Atlahang Ramoji to respond to any of the questions, please try and stick to the 3 minutes. Atlahang? Atlahang,
Okay,
you?
There was one of the questions that stuck out to me, but I'm not sure how to respond to it. Oh, it says, is the Constitution a document of convenience for the powerful and curse to the powerless masses? It's very rare to find questions like that. It's I don't know how to put it, but I don't want to speak for the Constitution, but on my behalf and on my opinion. But I feel that the Constitution could do better improvements in terms of the powerful and the powerless masses. So hence, it has to do with that specific question. I feel like as much as the Constitution is doing something about it, but I feel like there could be more done. I cannot really point a finger on what they could be done, but I feel like people could be heard, like on Professor Maysfield had said that 8% of cases of rape have only been successful, meaning practically those people have gone to prison or gone to jail. Why are those people not being heard? Why are they not being listened to? Where is the core of the problem? We should look at the of the problem. Like, where are we going wrong as the Constitution, you know? Thank you.
Thanks very much, Atlahang. Can we then have Steve?
Thanks, DM. I think there must be emphasis on the point around the rule of law. You know, in most simply put, that laws must be applied equally to everyone in a democratic state like ours. And in this case, the principles of, you know, of which the application sticks around, it's really that the laws must be clear, and our Constitution is very clear. It's publicized, our Constitution is publicized, but it must be stable. And I think the issues and the points raised by all panelists, you know, raises the issue around stability and whether there is just application of this law. And if we can't ensure that citizens, but as well as the law enforcers, are at par excellence of competence and application of delivering justice, delivering ethical and also interdepartmental approach to applying the rule of law, we miss out in that. And the essence that we are challenged with here, it's also of the behavior of South Africans. You know, I think we have taken lightly the Constitution, and we are actually seeing more and more South Africans who likely are squandering, you know, this Constitution. We cannot afford to really squander this Constitution. And I think every point that has been raised also relies about us and our responsibility towards this very same rule of law, but as well as the arms of states in applying the protective and the promotion and fulfillment measures in place. So at one stage, we have to just put our finger in it and surely deliver the just approach in a time. We can't delay justice. We can't accept inequality. We cannot also look when things happen in front of us and we do nothing about it. So our responsibility to make sure that some of the legislative pieces that are missing, including such as decriminalization of sex work, as well as hate crimes, are key and are equitable for all. For us, it's an application. Thanks, dear.
Thanks very much. Then to Mr. Hatang. Sello, you're muted. You're muted.
Apologies. I was thinking, what do you say in 3 minutes? And I thought maybe we need to then be talking about the next 25 years. How does that picture look like? And I'd like to put a few thoughts across in terms of that next leg of the 25 years. I think the first one is to ensure that we give youth a greater voice. Adv Bongani this morning demonstrated again why we need to keep giving young people a voice so that they can then keep pushing boundaries and that they let us feel that we are pushed. The second one is building a more accountable state. And I use not just government, but state, we as the people, that we must be accountable, that we must hold each other accountable. The third one is the protection of whistleblowers. If we are to break the back of corruption and other problems that are in our society, we have to do that. The next one is building a more inclusive society. And on this point, it's important that we kind of reflect on how this inclusive society should not just be something that we speak of, but actually we keep trying to achieve, because it is possible to build such an. The next one is about the issue that Steve just raised on the rule of law. I think if there is law, we just have to make sure that we become constitutional beings who then ensure that we build that culture of the rule of law. Rebuilding state institutions that were broken by or crippled by state capture can help with that kind of system of rebuilding, of bringing back the rule of law. I want to close off with just a thought that dreaming, the Constitution is about a dream, but dreaming is not enough. That it's time that we then ensure that we don't just hope for what's possible, that we have to work hard for that society that we dream of. We have to ensure that we lift early childhood development from where it is to where it should be, that we ensure that our education is the one that empowers our children, not just to focus on matric, but ensure that we start right there in the root. So I want to end off there and say that each one of us carries that responsibility to build that society that we dream of. Thank you.
Thanks very much. Actually, people were a lot better behaved than they were originally. So Judge Sachs, you can have a little bit more time, which I think is also, you are a institution. So I think that's important. Let me just also raise a point that maybe you can also respond to. I'm getting criticized for not talking about an anti-vaxxer input, who says the religion of COVID-19 led by the World Health Organization and imposed on us through those we elected as leaders is threatening the very core of the Constitution, the Bill of Rights. Our rights to bodily integrity as enshrined in the Constitution is being eroded by imminent mandatory vaccinations, which will constructively force people to take part in ineffective and unsafe medical experiments, in brackets, gene therapy vaccines. The vaccines have killed and injured many, and our government is hiding this genocidal potential. And is there a document is the Constitution a document for the powerful and a curse to the powerless masses? Obviously, you can, Judge Sachs, you could respond on that. I mean, really just to say that, you know, I'm not sure how this government can hide information. The internet information is freely available. I am not a doctor, but, you know, anyway, I have raised the point, Judge Sachs, and ultimately the issue as to whether it's constitutional, unconstitutional to say if you don't get vaccinated, you can't do certain things. It's going to be up to the Constitutional Court to decide which is what it should be. But Judge Sachs, if you could wrap up, you have a little bit longer, maybe 7 minutes or so, or yeah, 7-10 minutes.
Okay, I won't hold it against you, John, that you refused to call me Judge Albie, but I'm speaking now not as Justice Sachs. The courts will deal with the vax matter. So I'm now speaking as Albie, and let me get that out of the way. I too have a right to my bodily integrity, and I have a right not to be invaded by the virus if I'm going about my work in the ordinary way, from people who refuse to be vaccinated, who become in that sense potentially lethal agents of invading the bodily integrity of others. And the question really is balancing out the claims of individuals who don't want to be vaccinated. They might put it on all sorts of different bases and grounds, that's their right to do so, but who refuse to acknowledge that by so doing, they're endangering the bodily integrity of others. And there it always becomes questions of limitations and what's appropriate. We take vaccinations for measles, for mumps, our kids get vaccinated, that's been happening all the time. Now there seem to be major campaigns, sometimes given a political slant, to get people to refuse, not to hesitate, to refuse to take the vaccination, which is a public health matter. So it's an issue that will go before the courts. Private companies can make their decisions. Discovery now has found a huge uptake of people, 94% I think, have agreed to be vaccinated. Whether access to public places and spaces, whether the right to work can be jeopardized, often these things can be balanced out. And so if somebody has a true religious objection, then if they can prove through taking the tests that they are not carriers of the virus, maybe an exemption can be created for them. But I don't want to go too deeply into that. The justices will deal with the issue. Safe to say that I feel the allegation made by the person sending in that question is completely misfounded. It's not based on science, it's not based on reality, and the people who will suffer the most will be the unvaccinated, who tend to come from the poorer sections of the community. They will suffer the most from the approach that's being adopted there. The two issues that I'd like to deal with are corruption and is the judiciary protecting the powerful? Let me start with corruption. There were two themes that turned out to be very important in South Africa that we didn't really envisage when drafting the Constitution. And we didn't create special provisions in the Constitution to deal with them. The one was HIV. And the impact of the pandemic was enormous. It was really threatening to destroy South Africa. There was a sense of helplessness, hopelessness, not aided by a denialism on parts of those in authority. And the specific theme of discrimination on grounds of HIV was not included in medical status in the list of prohibited areas of discrimination. But without difficulty, the Constitutional Court said, in the case of Mr. Hoffman, who wanted to be a steward on the South African Airways, was told you can work on the ground selling tickets, but not pouring coffee because you're HIV positive. And we said that is unfair discrimination. It didn't slot in, obviously, in terms of any of the categories mentioned in Section 9, but it was such a grievous invasion of his right to work, of using ill health. You don't say people can't serve coffee because they have cancer. This was based on prejudice, and we declared that to be unconstitutional. But more significantly, in the Treatment Action Campaign case, the court ordered that the government was obliged to make antiretrovirals available to women about to give birth, women living with HIV. And that saved South Africa. If there was, Constitution did nothing else in 25 years, that decision of the court, which arose from people on the ground mobilizing, tens and scores, maybe hundreds of thousands of people living with HIV mobilizing to claim their rights. It came because journalists picked up the issue, civil society was strong on the issue, and it came because we have legal bodies willing to craft a clearly focused case based on the Constitution, and the Constitutional Court unanimously deciding that antiretrovirals had to be made available. So this is an example of the court not protecting the powerful, right to the top of government, but protecting the people on the ground. And that's been the role, certainly the 15 years that I was on the court, that I felt I and my colleagues all felt totally committed to. So when it came to corruption, corruption was not mentioned in any of the themes in the Bill of Rights, and there were no institutions to protect democracy solidified around people having a special role to deal with corruption. So we have the public protector deals generally with conduct in the administration. We have the Auditor General, especially protecting the books of all the agencies of government. We have the Commission for Gender Equality dealing with that issue. We don't have a commission or a body in the Constitution dealing with corruption. And maybe looking back now, it was not a failure on our part, but something that maybe should be considered for an amendment, a constitutional amendment, to create a body with the same independence that the other Chapter 9 institutions have, devoted to dealing with corruption, protecting whistleblowers, ensuring that their prosecutions, creating information understanding, and independent of the agencies that might themselves be corrupt, not subject to their control. And I think that's something that's emerged that this 25th anniversary, we should seriously think about, hopefully to get cross-party support for a body of that kind. Even the people who are in positions of authority or in parliament, whatever party they might belong to, who might have fingers being pointed at them, hopefully they will at least support the principle of an organization, institution of that kind. What the judges did in cases dealing with the dismantling of the Scorpions, the majority of the Constitutional Court judges said, even although corruption is not mentioned expressly in the Bill of Rights in any way, and there's no Chapter 9 institution dealing with it, corruption threatens the achievement of all the other rights. It undermines it. It allows people in power who should be upholding fundamental rights themselves to take kickbacks, to have interests outside. It's not just the deviation of money, it's the destruction of virtue, integrity, and honesty, destroying the trust of the people in the agencies of government. And so they said the need for having an independent investigative body investigating and prosecuting is a constitutional requirement. So in that sense, the judges, in a creative way, consistent with all the values of the Constitution, to protect the poor and the vulnerable, not the powerful, the judges said, we do need to have, and that's how the Hawks came into being, and that's provided the basis for now helping to transform and strengthen and invigorate the prosecuting authorities happened. The last question I want to deal with is the allegation made that the judiciary, particularly the Constitutional Court, is there to protect, is violating the Constitution itself. And I'm thinking, what's behind that allegation? It came through to me so strongly at the time of the insurrection, or the, whatever you call it, the looting. And people were speaking about detention without trial. Now, I feel so strongly about detention without trial. I was detained without trial. I belong to that generation detained without trial. I was the one that early on in negotiations saying detention without trial must be prohibited expressly in our Constitution, because that was the foundation of the tortures, the violations, the destruction of our whole criminal justice system, putting the security police in effect in a much more powerful position than any judiciary, any judges. And detention without trial meant we could be picked up, thrown into jail, kept in solitary confinement for 90 days, and another 90 days, and another 90 days, eventually without limit, that we could be tortured and beaten up, brought as witnesses. If we didn't say what the security police sitting in court wanted us to say, they would bring others and others and more and more and more. It was something gruesome and horrible. And to say that the decision of the Constitutional Court to make the order that it did in relation to former president, for clear defiance of the court order involved detention without trial, that's alleged to have been a form of protecting the powerful. For me, it's exactly the opposite. It's avoiding impunity. I don't want to get into the merits of the case, and I don't want to say anything about the former president, who we were comrades together for 10 years in Mozambique. We stood at the gravesides of people who'd been murdered, and we sang freedom songs. I have nothing but emotion remembering those days of ourselves together in the struggle. But time has moved on. People have made their decisions. They have to take the consequence of their decisions. But what I felt at the time of the looting was, I'm so glad we're not using the methods against insurrection that we in the freedom struggle were trying to promote, to overthrow apartheid with all forms of resistance. We're not using the methods the apartheid regime used at that stage. We don't throw people into jail. We don't have an all-powerful secret police. We don't have people being picked up at dawn and disappearing. We don't have the assassinations. And I'm glad we don't have those things, even if it takes longer. The rule of law exacts a price. It exacts a price. You have to follow proper procedures. It takes longer. It requires proper evidence. It allows for defense and cross-examination in ways that were not permissible before. It allows for rights to information, to look at dockets, to much more fair trial than was ever possible in the apartheid days. And so for me, maintaining the rule of law is fundamental for the rights of the poor, the marginalized, the dispossessed, the neglected in our society, more than of the wealthy. The wealthy don't need the rule of law. They've got money, they've got power, they've got connections. They can move off to another country if they're unhappy with the way things are going. It's the poor who can't move. It's the poor who most need the Constitution, most need their rights, who require the rule of law. dependent upon the judges being independent, doing their duty, and not being bothered by allegations and charges made against them that many people believe, many people believe, are designed to defend crooks, to defend those who are malicious with regard to the application of the Constitution to ensure equality for all. Equality for all means however high you are, however low you might be in society, you have to be subjected to the processes under the Constitution. You have to be accountable for what you do. If you've misbehaved, if you've been corrupt, if you've done things that are impermissible under the law, you have to stand trial, you have to take the consequences. If you're asked to present yourself to commissions of inquiry like everybody else, you're not in a position to say, somehow I'm exempt from that. Now, this is Albie speaking. It's not Justice Sachs speaking. The courts will speak for themselves. I'm just speaking now as a citizen, as a human being. I'm so proud of our Constitution. I'm so proud of our Constitutional Court. I haven't been on it for a decade now, so I'm not boasting about my own contemporaries. I'm so proud of the decisions that are coming out, decisions that are being picked up by courts throughout the world, because they represent that sense of justice, that sense of humanity, that thoughtfulness, and a very, very progressive vision. It's our strength, it's our virtue, is embodied in the spirit of the Constitution, in the institutions that are truly upholding what the Constitution demands of them. And I would put the Constitutional Court and my colleagues on that court and the new future Chief Justice. We have 4 wonderful candidates. It's going to be very hard to choose between them. We've got quality in this country, and the Constitution is at the core of things that are good, are promising, are decent, that are linked up with the struggles of the past, the sacrifices that were made, the dreams that we have to have, and the dreams that have to be realized in practice.
Thanks very much, Judge Sachs. The Minister has now joined us, so I will be handing over to him, or back to Advocate Tipanyanu and to him. But just to finish this session, look, there's been a number of panelists, there's been a number of inputs, and there've been a wide range of topics that people have raised. But my own view is that we have come far with this Constitution. It has done a lot. Also to say, I think nobody has mentioned it, that it is amendable and reviewable. In fact, it's meant to be reviewed by Parliament every year. So it's seen as a living document, not something cast in stone. But I think there's a lot that still needs to be done. And the issue is for all of us in South Africa to look at, rather than expecting somebody else to do it, what are we going to do to make South Africa a better place and ensure that it is, we are living and South Africa is being governed according to the Constitution. Having said that, then I'll hand over to Advocate. Thank you very much to all the panelists. I'll hand back to Advocate Tipanyana, and if you've got the Minister, but that's your role. Thank you very much, everybody. Thanks to the panelists.
Thank you, Deputy Minister and colleagues, Judge Albie, and other panelists. I would now hand over to the DG of Justice to introduce the Minister, and thank the Minister as well for making time for the event despite his other commitments. Thank you.
Thank you very much, Program Director, Advocate Tipanyane. I have the honor of introducing the Minister and calling him to the stage, Minister Ronald Lamola, the Minister for the Department of Justice and Correctional Services. I think it's well known to many of you and South Africans. He doesn't need much introduction, all except to say that he has been a minister since June 2019, until now. And part of the mandate of the ministry includes the administration and the custodianship of our beloved Constitution. Minister, I yield the floor to you. Thank you very much. Minister Lamola. Program Director, I'm trying to check. Minister was online, but he's connecting from the Eastern Cape in a way, was attending a funeral. So there might be some challenges. Just give us a minute.
Thank you, DG. I don't know now, how do we fill in the minutes? Well, DG, if the minister is going to come, maybe then we can start by just giving us a short background then about the minister, with the hope that by then he'll be here.
Program Director, we are getting the minister connected. It does look like just lost him for a. And he does appear online. So we're trying to speak to the colleagues who are next to him.
Thank you.
Program Director, in the meantime, you can just deal with that question on section 2035 of the Constitution.
Okay. Can I then maybe then ask some of the panelists to speak to that? Either Judge Sachs or the DM himself, if it's possible. Thank you.
Sorry, what is the question?
DG, can you help a bit?
The question reads, Program Director,
DG, is the minister available, or can we then respond to the question on Section 35 on the right of victims or the plight
Yes,
and the support?
yeah, that's Section 35. The question was, why do we have more rights for the perpetrators, Section 35, and not for the victims? The question says, may I ask for a clarity on Section 35 of the Constitution dealing with the rights of accused persons, but nothing detailed about the rights of victims of those perpetrators? How do we deal with that? That's the question.
Thank you, DG. Can we then get a response either from Judge Albie or Deputy Minister, or both?
Yes, I'm putting up my hand because I'm going to have to leave the program. I have to go to Belfast, Northern Ireland for another thing. And I'm very proud as a South African judge. I then go to Harvard later on, and then to SABC in the evening. So it's a very heavy day. It's not Section 25. Section 25 deals with the land issue and the right to property. It's another whole thing for a whole program in itself. But the theme of the rights of the defendants, it's a very valid question asked, but you don't deal with the rights of defendants by denying the rights of the victims by being cruel to people charged with having done bad things. Each are entitled to their rights, and a lot has been done in the last 25 years to protect, in particular, children witnesses with special procedures. They used to be terrified by lawyers firing questions at them, and also in GBV cases and sexual crimes cases. Special courts have been created to protect usually the woman bringing the complaint, so that they don't have to look the accuser in the eye directly, but they can give the evidence and their testimony in a very free way. There are also other examples of things that can be done to support the victims of crime in different ways, but I think that's an area that could be very much expanded. But the biggest rights that the victims of violence and fraud and so on can get is for the law to take its course, and for those who are guilty of the offense to be properly punished, found guilty. And that means strengthening the law enforcement agencies, strengthening the prosecution, strengthening the judiciary. That's the main protection that can be given. But also every person coming to court to lay a charge, to tell the story of their trauma, has to be treated with great dignity, with great respect, with great courtesy. If they go to the charge office in the police station, they're entitled to those rights as well. And many countries provide for compensation for victims, particularly of violent crime, in different ways. We're struggling with so many different themes in South Africa now. That's not a very, very well-developed area, but at least we can insist on strong, effective law enforcement, number one. We can insist on great dignity and courtesy and respect for people who are reporting crimes against them, number two. The case of whistleblowers, other forms of protection, witness protection, all those things I think are very important. I think the minister is now available, and so I will bid farewell to the panel, to everybody else. Minister, I have to go to Belfast in a few minutes to participate in the whole theme of amnesty for British soldiers who committed violations against Irish people fighting for independence or fighting for unity of Northern Ireland. A complicated issue there. South African experience can be quite valuable for them. So I hope to be excused by the minister and excused by the program director.
Thank you, Judge Albie. Travel well and good luck in your events. Can I then kindly welcome the Minister of Justice and Correctional Services, Mr. Ronald Lamola. Over to you, Chair. Sir, thank you.
Yeah, thank you very much, Program Director. My network is a bit difficult. Maybe let me try switch off the video. Hopefully it will be better.
Yes, please. You are free to do so.
Thank you. The Deputy Minister of Justice and Constitutional Development, Mr. John Jeffrey, and Justice Albie Sachs, Chairperson of the South African Human Rights Commission, Advocate Bongani Majola, United Nations High Commissioner for Human Rights in Southern Africa, Ms. Abigail Noko, the CEO of the Nelson Mandela Foundation, Sello Hatang, the Director of Access to Chapter 2, and the Deputy Chairperson of South African National AIDS Council, Ms. Steve Letsike, founder of Lawyers Against Abuse, Professor Bonita Meerveld. The 10th of December is a day of great significance in our country. Although it is not designated as a holiday, it represents a moment we should never be shy from celebrating, no matter what the challenges of the day are. As today, we face a number of challenges, including the pandemic, but the Constitution has put us in good stead to be able to steer through these challenges and to do so while respecting the human rights of all South Africans. It was for the first time during this pandemic that we had to limit the rights of all South Africans, and the limits have been tested through our court system. Our history is too gruesome for us not to mark the day in which we set a new path into motion. As we mark this day, I will admit that we are certainly not where we want to be as a nation, but we can also say we are not where we were prior to 1994. If you had said to my mother and father, who were both farm workers in a Bantu stand in the Eastern Transvaal, as it was called then, that in just over 2 decades, one of their children will be serving as a democratic government as a minister, they will have probably not believed you. They will have laughed you as telling a very serious joke. Equally, if you had said to Oliver Tambo, Nelson Mandela, Walter Sisulu, and Albertina Sisulu, Dorothy Nyembe, Lillian Ngoyi, and Ruth First, amongst others, that after 25 years of democracy, our society will still have the hallmarks of an untransformed society, they too will have still struggled to believe you. Though they had learned lessons in the various countries across the globe, that governing is not an easy, but they would have thought that we will have achieved or reached certain level of equality in our country. Our democratic society is different from a society that was characterized by oppression, racism, and human rights violation. Ladies and gentlemen, a careful reading of history reveals that South Africa as a nation state has a special relationship with this day. In the same year in which the National Party fully endorsed and implemented colonialism of a special type, the world stood up and applauded Eleanor Roosevelt when she stood in General Assembly of the United Nations and said the following, and I quote, "We stand today at the threshold of a great event, both in the life of the United Nations and in the life of mankind. The Universal Declaration of Human Rights may well become the international Magna Carta of all men everywhere. Of course, we now know that this great day in the history of mankind had no impact on the apartheid government. Chief Albert Lutuli, when accepting his Nobel Peace Prize on the 10th of December 1960, said the following, and I quote too, "It is idle to speak of our country as being in peace, because there can be no peace in any part of the world where there are people who are oppressed." Close quote. As the world marks International Human Rights Day, it is hard not to think that very statement by Chief Albert Lutuli echoes loudly in the streets of occupied Palestine. And right here on our continent, Western Sahara's independence is still a matter of conflict, and the Tigray region remains volatile. I am citing these examples to show that in spite of progressive intentions and achievements, a lot still needs to be done by all of us in this country and the entire group, and that no nation is an island. We all need a peaceful world, for the world to thrive. These, by and large, are issues which are in our direct control as South Africans and as government, but we have got a role to play in all sectors of society, but also in international solidarity. The Constitution has to be a catalyst for equality under these circumstances. In this vein, we need to be unapologetic in pursuing the goals which the Constitution has set us for. Since 1994, we have seen a substantial body of new laws which have emerged from all levels of government to fulfill the mandate of the Constitution. We have created new institutions, and in some instances, we have given them even more powers informed by the learnings and the teachings of our journey as we continue to reform the state. In pursuit of a democratizing land reform, we passed the Land Restitution Act, strengthened security of tenure, and facilitated access to housing and the provision of social assistance for those who need it. We firmly believe that land reform should be anchored on the restitution of land rights that has been dispossessed in terms of colonial laws, improvement of security of tenure for those whose land rights were weakened by apartheid, and land redistribution. We equally advocate for multiplicity of land ownership or land tenure system in our country, which will mirror our social and economic construct. It will facilitate economic and social participation by any landowner. Through land reform, we want to restore the dignity and the economic power of those dispossessed by the apartheid regime and change the ownership patterns. We will ensure that the National Assembly adopt the Land Court Bill, the Expropriation Bill, and the Redistribution Bill that is in the pipeline from the Department of Rural Development to ensure that we are able to change the land ownership patterns. But we also have to equally capacitate the state so that it's able to discharge its land reform obligation, because some of the challenges that have affected or besieged our land reform program has been real challenges within our state that has struggled to implement some of these progressive policies in terms of land redistribution, land restitutions, and the non-promulgation of the Expropriation Bill that led to the Expropriation Bill, the Expropriation Act of 1975, to be still lingering or being the legislative instrument that is being used to date in terms of expropriation. These are some of the bills we have to finalize, and some have been finalized to address the systematic inequalities and unfair discrimination that manifested in the institutions of society and practices and attitudes of South Africans. We have also put in place legislation directed at advancing human rights, the Promotion of Equality and the Prevention of Unfair Discrimination Act, the Promotion to Access of Information Act, and the Promotion of Administrative Justice Act. In recent times, pieces of legislation have featured heavily in our courts with the intention to hold those with the executive powers accountable for their decisions, and also holding individuals accountable for various forms of discrimination. We also have considerable amount of work being done to transform both the philosophical ethos of the state as well as institutions within the state. As we look at the judiciary today, it is no longer white and male dominated. Although the gender composition of it has room for improvement, progress is both tangible and visible. When one looks at our jurisprudence as a nation, one can see a significant departure from legal positivism which permeated under apartheid era. With cases like the Bear versus Magistrate of Kaelicha, we saw gender equality being entrenched in African customs at the instance of the Constitution. Even most recently, we saw the Constitution prevailing over individuals who occupied very high offices in the state. When one reviews the Constitution over a period of 25 years, we certainly do find progress. This should tell us one thing. As a nation, our Constitution can be a document that binds us together towards a better life for all. We still have to work hard to achieve most of the ideals of the Constitution. For our nation to prevail, we dare not lose our robust human rights culture, which has grown from strength to strength in the past 25 years. This human rights culture must even be prominent now by all role players in society in a period where COVID-19 pandemic has had an impact on our people's livelihoods and more broadly in the economy. The world's richest nations continue to be on the wrong side of equality throughout the unjust hoarding of vaccines and closing out countries like ourselves. When we identified the Omicron variant, they used it against us instead of embracing the science that we have brought and improve our fight against COVID-19. Our biggest threat to our democracy and this institution is not only the politicians and big private companies amongst us who seek to override this foundation, but also citizens who choose to withdraw their participation. And the recent local government elections are a clear case in point. Our democracy and constitution does not come alive only at the ballot. It is with us in the shareholders' meetings where millions are dispersed for the executive at the expense of workers. It is with us in the school governing bodies and university councils where exclusionary policies are adopted. It is with us in the forums where men slut shame women and treat them like personal properties. It is with us in the community when we choose to discriminate on our fellow humans on the grounds of race, gender, sexual orientation, and even nationality. Our constitution is a living document. It must live with us anywhere we go. And we must abhor, condemn any forms of discrimination or any form of abuse against the LGBTQI community. It should be the responsibility of all South Africans to fight against this scourge and the scourge of gender-based violence. Every individual has it within himself to fight against this pandemic, against this horrible and abhorrent behavior that is sometimes found in our communities and in society at large. We have to extirpate it. We have a role to play through our system and including the criminal justice system. But society has a bigger role to play to prevent it from happening. It should be a shame that it still happened 25 years into our democracy. Let's hold hands together and ensure that the Constitution continue to be a living document. Thank you very much, Program Director.
Thank you, Minister, for your remarks. And the message has been heard loud and clear. Certainly a lot of work still has to be done in ensuring that we do get to our destination of this long journey. Can I then hand over to the Director General of the department for a vote of thanks? Thank you.
Program Director, thank you very much. And we really appreciate the manner in which you steered this program, despite the glitches that we nearly had, but we appreciate that we got to this point. And Minister, thank you very much as well for your keynote address and the time that you availed in order to be with us here. I want to thank the Chairperson of the South African Human Rights Commission, Adv Majola as well, and the head of the UN Office for Human Rights in Southern Africa for your availability to be part of the high-level address. And equally, we thank the Deputy Minister, Mr. John Jeffries, for facilitating the panel discussion. And we also thank the participants, the panel members, particularly Judge Albie Sachs, and the CEO of the Mandela Foundation, Sello Hatang, and the Val Heritage activist, Atlechang, who also participated, and Professor Bonita Meyersfeld, all of them, the participants in that panel. We want to thank you, but also thank our partners in this case, the South African Human Rights Commission, the Nelson Mandela Foundation, the Constitution Hill Trust, and all those who have worked with us to make sure that this auspicious event was a success. And the summary that the Deputy Minister has given and the way forward is issues that the department, together with our partners, will follow up on as we continue to observe the 25th anniversary of the Constitution. You'll recall that on the 4th of February, 1997, the Constitution came into operation, and we'll continue to work together to make sure that we mark that day next year. COVID permitting, we had desired that this meeting will have been live in Sharpeville. So we hope that things will be better by next year. We should be able to have this event, at least in some form of hybrid or in person. But Program Director, we want to really appreciate you and thank you as well for having steered this program to this time, and everyone who participated and attended. We couldn't have all the questions answered, but some of those questions will form part of the discussions that we continue to arrange throughout the country in form of seminars and symposiums, and they will indeed be followed up. And we have taken note as well of Professor Tuliba Donzela's passion about the implementation of Chapter 5 of PEPUDA Act. We continue to work on it. We hope as part of the activities around the 25th anniversary of the Constitution, we'll be able to finalize that program. We'll continue beyond the 4th of February as the 25th anniversary plus, moving to the 30th anniversary. As the DM has said, this is a living document. South Africans should discuss it, should debate it, dialogue about it, and make proposals for its improvement. But thank you very much for everyone who attended. We apologize that we slightly went beyond the mid-date 12 o'clock time that we had scheduled. But it was a great session that we had, very enriching, and we will take some of the issues that have to be taken forward. Thank you very much, Program Director.
Thank you, DG, colleagues, ministers, and other VIPs. Thank you for attending. Can we now declare the session officially closed? Thank you and have a good day.